it is very clear that the power of the General Court Martial to order detention collapsed. And it collapsed in the presence of the Attorney General of the Republic of Uganda, who is the first respondent in this application.
My Lord, Dr. Besigye has no access to a personal doctor right now for proper medical examination. And that is a very serious matter, my Lord, because in as much as by a cursory look here, court can make an observation that maybe is improving. My Lord, his state, the circumstances compel that an order be issued for Dr. Besigye to regain his liberty.
This is the same judge that sent Kakwenza to prison instead of sending him to the ICU after grave torture. This is the same judge that said the cash bonanza at Parliament was legal. At the same time, this is the same judge that is sending Dr. Kiza Besigye back to prison instead of sending him to hospital.
This cadre judge, shame on him. Shame on him to send back to jail a man whose health is deteriorating very fast. But it's all President Museveni and his insane son, who is the army commander or chief of the army, who are holding all of us in captivity. We must liberate ourselves. Enough is enough.
Omusumba ye n'asaba n'agamba bagawugule gagende wakumuluma 13
naye gavumenti yatumukuzanira ku mitwe
era mbyagalira ddala pulezidenti wange
betwasaba bajje batusabire tebakoze eki tebalabise
tugenda kwekalakasa paka eza paka kulira
My Lord, it's our humble prayer.
BBS.
It's our humble prayer.
He's saying that he would not treat was because of the people surrounding him. Maybe if it would be accommodated. Okay. This year, and your best back here. It's more special.
Your court has elected nothing has come.
Journalists create space for them to come this way. Yeah. Let's create a way.
For me, once someone is sick, I'm not going to continue with that person in court. You have to go back. That's what I want to say.
Let's clear.
By police.
It will control us when we're in prison.
Yes.
Do you remove the mask secrecy? Can they remove?
Yes, but
Can we give way? Yes. We only have 2 minutes for this session.
Man can walk in. See you like this and they are escalating as well.
Members of the media, can you please give
May it please you, my Lord. We beg to proceed with the application. My Lord, this is an application for habeas corpus ad suppliciendum brought under the provisions of section 38.
That's much that break it down for our members.
That's the language of the statute, the act, my Lord.
but you can break it down.
Most obliged. My Lord, this is an application brought under Section 38 of the Judicature Act for this writ of habeas corpus, which is for an order that Dr. Chiza Besigye and Obed Rutare here be brought before you, my Lord, for the respondents to show cause why they are keeping them in detention without a valid remand warrant or any valid court order or pending charges against them. No. That's not the case, my Lord.
Someone is in detention and you don't know who is holding him. And the problem is, so you need the body dead or alive.
Second leg to the
So the person is here.
Yes, my Lord, but my Lord, when you look at the strict constructional interpretation of Section 38, it's not mainly restrictive, but it has to be in cases where the person, his whereabouts are not known.
So now the whereabouts are known. So what is the basis of your application?
The application is for an order of release, my Lord.
Now you argue that.
Most obliged, my Lord.
The body is here.
Yes. My Lord, the brief facts are the Honorable William Nima and most obliged, my Lord. But my Lord, our prayer is grounded on that particular section 38 rather of the Judicature Act.
Have they replied? That's why I wanted to stop you there. And then the next administrative.
With your permission, my Lord, my Lord, thank you very much. First of all, for the speed with which you have acted. Number two, my Lord, the summon is to the respondent to bring the body and justify why he continues in what we contend is unlawful detention. They have not shown up, but at least they have brought the bodies of the person, having failed to come and justify the detention. I would implore you, my Lord, before you go back to the administrative pronouncements, to order for release.
You are rushing us. You are rushing us. So can I ask all the journalists to move out? It's an administrative order. You don't want to go out, it is up to you. So, okay, I can see Mr. Rukwago is shaking the head. No problem, they can stay. We are not hiding anything. For me, as a judge, I'm very happy that our person is in court. So I'm repeating that part, but probably the sticky part of the application as a little bit weak. So what we have focused on is whether the continuous detention is justified. Yes, yes. And probably media, it just seems to be any we all agree.
His condition has improved.
No.
For me, I'm really clear that what I've been written about is status of the 1 minute.
3 minutes, my Lord. Most obliged, my Lord. My Lord, I've already addressed you on the question of liberty under the authority of Kyagulanyi and the Babla Itungo. One aspect which I needed to point out in this particular authority, still on page 14, liberty is defined by Black Law Dictionary, freedom from arbitrary or undue external restraint especially by government. And this is, my lord, the import of the spirit of Article 23 of the Constitution, which guarantees liberty of Dr. Chiza Besigye and Obedi Lutale. In this particular case, my lord, under Article 23, first of all, they have not been informed of any offense under which they are, which they may have committed, and the reason why they are in Luzira, and there is none. Two, my lord, Dr. Besigye has no access to a personal doctor right now for proper medical examination. And that is a very serious matter, my lord, because in as much as by a cursory look here, court can make one observation that maybe is improving. My lord, his state, the circumstances compel that an order be issued for Dr. Besigye to regain his liberty, to be able to access a medical facility of his choice, so that he can be thoroughly examined to assess his health situation and get proper or specialized treatment. My lord, the final authority I would like to cite on this one is Chwanka John and others versus the DP Director General of Internal Security Organization. It is miscellaneous cause number 9 of 2021, where again this honorable court decided that a writ of habeas corpus applies in cases of illegal detention and is meant to secure the personal liberty of a person under such illegal detention upon determination of the validity of such detention by the court granting the writ. I agree with the counsel for the applicant that preservation of personal liberty is crucial and should only be derogated from in exceptional circumstances where there are court orders. And that is the position of the law. So this particular law, my lord, is reinforced by Section 15 of the Human Rights Enforcement Act. My lord, and this is where we are grounding our prayer. Section 15 of the Human Rights Enforcement Act of 2019.
Maybe to share some information with you, counsel. There is a separate.
So my lord, one of the orders that was read is that these trials cease and be transferred. In there, they could have added, cease, the detainees remain in custody until the cases are transferred. They did not do so, and they were wise not to do so, because they had just pronounced themselves on the illegality of the basis of those charges before the court martial. So my lord, as we speak, there are no charges pending anywhere in Uganda or elsewhere, apart from a case in Buganda Road on which the first applicant is on bail. His bail is being extended, but he goes back to another location, not to his home. That is the only one that is pending. But in that one, his liberty was given back to him.
It is very clear that the power of the General Court Martial to order detention collapsed. And it collapsed in the presence of the Attorney General of the Republic of Uganda, who is the first respondent in this application. Whereas it is urged by the first respondent in the affidavit of Mr. George Karemera, paragraph 9, that the Supreme Court did not order release. There was actually no necessity to order release.
So, yeah, on that point.
Yes, my lord.
So you are trying to read in some words in the decree.
No, my lord.
You're saying it was not necessary, but it said so in so many words. You are reading in.
I am not even wanting to go there. I am only restating the position of the Constitution. Under the Constitution, liberty is guaranteed. Restriction must be justified, and that justification must be a lawful one. And in this particular case, the lawfulness would only be cemented on on a valid order of a court with competent jurisdiction. In the absence of it, there is no justification, and it is your power, my lord, and duty to order freedom to be reinstated. Away from the Prisons Act, my lord.
Because some people,
Yes.
your colleague, the Lord Mayor, my former teacher, are putting me under some weight that I should think now. But I didn't write it. How do I write it?
My lord.
Can you address that?
Yes.
I can write it
Yes, my
in
lord.
4 hours?
Yes, my lord, now is contextual. And what we are saying by now is that upon conclusion of our submissions, the court be pleased to begin writing the release order. In the same realm of context, my lord, I now propose to take you to the context of the Supreme Court's order of transfer, which has been misconstrued. My lord, this must be looked at from the perspective of Article 120 of the Constitution. The Supreme Court did not order the Director of Public Prosecutions to take over, because that is barred by the Constitution, Article 120. In effect, the Supreme Court told the first respondent, if he's interested in any prosecution, to go and start de novo. Do a fresh investigation, a fresh complaint. What one would expect is the state to report to the nearest police station or post and report and start with the first information. Why? Because any warrant of court has an expiry date and tenure. Thank you. My lord, with your permission, and I'm grateful, because the DPP cannot take over, the transfer order must be contextualized to mean, if you are interested, start a fresh complaint system. Go to the nearest police, report that these people are alleged to have committed offenses X. And when you do that, the DPP looks at the file, because the DPP even has the power to say, this one does not merit, and drop it at that stage. I was taking on the point that a warrant or detention order itself has a time limit. Bring back this person on this particular date. That is axiomatic. And the moment it expires, lawfulness ceases. In this particular case, the warrant of the defunct court martial was actually in itself expiring on the 3rd day of February. They could not extend or even terminate because they had ceased to exist. And since that time, the lawfulness, if at least it had not collapsed on the 31st day of January, died or re-died on 3rd. My lord, to contextualize Article 120 and the decision of the Supreme Court, I would implore you, and we shall supply a copy, the decision of the East African Court of Appeal in Kagenyi versus Musiramo and another. Kagenyi versus Musiramo and another, 1968 East Africa, page 43. The gist is this, that a transfer is not even possible if the court originally had no jurisdiction. The decision of the Supreme Court, or even the Constitutional Court before, are to the effect that from the word go, the General Court Martial had no power, had no jurisdiction. So there was nothing to transfer. That's why I want you to contextualize the decision of the Supreme Court. Finally, my Lord, on the question you did ask me, when we say that you be pleased to order now, the word normally used by lawyers is ex tempore of judgment. Oh, actually, I'll come back to this. The word is, it is usually used to describe an oral judgment, including reasons for judgment, given at the time of the hearing. That is the context of we propose and implore you to find pleasure in ordering release now. But this particular case of Kageni versus Musiramo was cited with approval in Rose Wanjiku Njau, Rose Wanjiku Njau versus Nicholson Philip and two others. Miscellaneous criminal application number 387 of 2012 by the Supreme Court of Kenya. To sum up, my Lord, in one sentence, the affidavit of Mr. George Karemera, which attaches a letter purportedly by the principal judge, and now you can see the bad faith, exchanged without reference to us, particularly those of us who went to the Supreme Court, does not place a lawful justification. It only talks about the administrative measures.
For the benefit of our media house.
Yes, my Lord.
Just give the essence, because you have made reference to that later.
Yes, my Lord.
Essence of the honorable principal judge's letter. What is it in principle? State.
My Lord, in principle, the Honorable Principal Judge is communicating measures taken by the judiciary administratively to guide the process of moving these files away from the deceased court-martial.
Let's bullet those measures. We can speak about 3 measures in the bullet form.
No, my Lord. The principal judge, the Honorable Principal Judge does not bullet those measures.
I'm talking about bulleting in our...
I'm avoiding the bulleting because I'll be reading into his letter, but I can read it. I have received rights to the Minister of Defense and Veteran Affairs and to the Director of Public Prosecutions. I have received the attached self-explanatory letter from the Honorable the Principal Judge, the Chief Justice, advising that files pending before the General Court Martial that were subject of judgment of the Supreme Court and in the captioned case be handed over to the Honorable Principal Judge for further management.
Bullet number 1, all
Yes, yes. This therefore is to bring, yes, bring them to the principal judge. The next is, this is therefore to bring the advice to your attention for your appropriate coordinated actions. And under whose authority are the applicants in detention. Number two, what is the criminal case number? The Supreme Court having said the prosecution ceases and with immediate effect by 31st. By fall of night 31st, the criminal case number for the General Court Martial ceased. The file could be there for investigation purposes. You and I could be, maybe not you, maybe I could be under investigation, my lord. God forbid, you should not. We need you. So the question is, under what criminal case number? And detained until when? The last time we had a detention which is unlimited in duration was under the Public Safety Act. And that one collapsed with the coming into force of our constitutional regime. Nobody can be detained indefinitely where there is no pending charge. That one will be a recipe for chaos in our country that anybody would detain. With that, my lord, I can only say that let nobody drag the judiciary into this detention controversy of, say, relying on the order, the letter of the principal judge, an administrative letter. Very unfortunate.
Ironically, we cannot run away from his jurisdiction.
My lord, if we are going to construe this as authority, the letter of the PJ, the next thing they will request you for a letter or granting a warrant to detain. And this was not a judicial letter. It was an administrative guidance to those persons, if they are still interested in prosecuting. Anything beyond that, my lord, is a persecution, and I would invite you to put a hold on it. I so pray, my lord.
The constitution cases there must be no detention without trial.
My lord, in a minute. Well, my lord, in 1 minute, Sam Muhoozi is my name. I'll just take you to Article 43 of the Constitution, my lord, where you cannot detain anyone without trial. There is no ongoing trial, my lord. Secondly, everything about that defunct General Court Martial was nullified. We cannot continue discussing putting something on nothing, my lord.
Sir, an administrative letter.
And an administrative letter, whether by the Chief Justice or Principal Judge, cannot be such authority to take away this provision of the Constitution, my lord. My lord, further, my colleagues have submitted about Article 123, my lord. If you look at 123B, my lord.
This letter is not by PJ, so it is by Chiliwachwana.
Actually, my lord, to conclude on the letter.
Correction.
To correct my statement.
Our statement.
Our statement, when I look at this letter, it is by Chiliwachwanuka, not the PJ.
Actually, I apologize because I got a soft copy. I've only seen this physical copy, my lord. I withdraw the reference to the PJ It is the Attorney General. I only got a soft copy here.
My Lord, to conclude, reading Article 123B, even the DPP, my Lord, Chiriwa Chiwanuka. Yes, my Lord.
Honorable by designation.
Honorable, my Lord, honorable by designation, but I knew that this court would take judicial notice of that, my Lord. Finally, my Lord, my reading of Article 123B actually precludes the DPP from even taking up any matters from the court-martial. It is very explicit. So most of the submission and the affidavit evidence that I've seen from the Attorney General is misconceived to the extent that it believes, the Attorney General believes someone can be in detention on orders of the Attorney General. My Lord, I join issues with my colleagues. Probably the rest will come in rejoinder. I'm obliged, my Lord.
Except I also wanted to express a little bit of there's been a lot of story in this court, and particularly, I mean, we love it when people express their minds, but you have to do it. Don't care. Well, if I'm short, I die once and I will divide, but maybe you will not have gained anything. So probably your client's matter would have gone before another judge, and that's a whole month of delay. So appeal to your audience, tone it down. It doesn't benefit them. Fortunately, I don't take the line that if you insult me, then I will take you on contempt of court. I allow people to, they can insult me the way they want, but don't extend those insults to threats. Thank you. Okay, that's about housekeeping. I hope the point is made. AG, can we listen to you? I wish the AG could have where to sit, and then the probably be able to speak to us. So, AG, have you replied to the application? So you listen to the complaints of hand. Can you take us back point by point why you oppose the application?
In law and nullity, it is not only bad but incurably bad. There is no need for an order of the court to set it aside or even discuss it further. My Lord, we shall supply this authority.
Okay, let me take you on.
My,
for a minute. If you don't need an order under this authority,
yes.
why are you here?
For setting aside, my Lord, as they are taking us off the road, my Lord. I'm justifying that the Attorney General has in a way succeeded into taking us into their administrative issues and their interpretation or misinterpretation of the orders of that court. My Lord, going back to my earlier submission.
You requested for 1 minute.
1 minute, my Lord. My Lord, if we are to go back to Article 43, my Lord, there is no, we emphasize, there is no trial in which a detention can stand. A transfer is not a trial. My Lord, even the trial anticipated, actually impending transfer, which may take even a year. There is no such transfer even. There is no trial, my Lord. Even the anticipated trial, my Lord, is misconceived under Article 123B. They cannot take over anything from the court-martial, my Lord, as submitted earlier. So a transfer order cannot, my Lord, be a basis for detention. The Attorney General dwelt so much on our submissions that we are reading into the orders of the Supreme Court. My Lord, They are the ones actually who are reading deeper and outside the orders of the Supreme Court, my lord, by saying that the order of transfer validated that warrant. The Attorney General is misconceived and misrepresenting or misguiding this honorable court, my lord. But my lord, even if there was a transfer as submitted by the Attorney General, my lord, that transfer would be a transfer of file, not body. We are talking about a detained body. A transfer of files cannot relate to continuing detention of a body, the body that was brought before you. And they have failed, my lord, to justify the continued detention. That is why we were feeling hurt that even our client was being taken from this court by the prisons any further, probably now back in Luzira. My lord.
You don't have to be hurt as counsel.
My lord,
Okay.
I take your guidance.
I can guide you. We are told together it's not
I'm obliged, my lord.
clients, so divorce yourself from the emotion.
My lord, when the law is being abused, but I'm obliged. I'm obliged, my lord. Well, I'll emphasize, my lord, and we shall rest our case. The transfer is not on body. If there's any transfer or at all, is on file, not body. We rest our case, my lord.
The transfer of the body is from prison to home. Indication of the body. Indication of the body. We should see that.
Your judge, we do leave the court premises today with the disillusionment in the way the matter has been handled. We are really disillusioned with the way the whole matter has been processed, because the writ of habeas corpus, which in simple terms is a prerogative order which can only be given by court in exceptional circumstances like this, where one's liberty has been curtailed without any justifiable or lawful cause, is a matter which has to be disposed of expeditiously. And when you look at the provisions of Article 23, read together with the Article 44, this right to a habeas corpus is non-derogable. It comes into play in emergency situations like this, where one's liberty is curtailed and their life is in danger. So Dr. Besigye was brought together with Obed Lutale this morning under very, unreasonable circumstances. There was an order that he be returned to Luzira without a valid remand warrant. Yes, we appreciate that court ought to have listened to all of us, both sides, before rendering a decision. But we made a good case for quick interventions, and we thought court would come up with the declaratory orders today about the legality of doctor's incarceration or the curtailment of his liberty. Unfortunately, it has not happened. Yes, we have made our submissions. We are grateful that the judge has listened to us, and we also appreciate the fact that he interrogated the circumstances under which Dr. Besigye and other prisoners of conscience are being detained in total violation of the Supreme Court order or directive. Unfortunately, we have not got a decision today. We are walking away from the court premises without a remedy today. So we expected a decision to be delivered today. It should be instant. And we brought out all the relevant authorities that would require that, honestly speaking, the justice of the case required that today there should be a remedy, there should be a decision, and it should be instant. Unfortunately, that is not the case. And to make matters worse, we have not been given any idea or clue as to when the decision will be given. We have been directed that tomorrow we write to the judge requesting for the date when the decision will be delivered. It's really baffling, because at least if he was not in position to give the judgment today, probably would have indicated that give me today or tomorrow, then I'll deliver the ruling within the course of tomorrow or the day after tomorrow. That was never to be the case. You see, you cannot again curtail one's liberty, which are duly guaranteed under the Constitution, the Bill of Rights, on account of the government red tape, bureaucracy. You heard their flimsy arguments. The state, the Attorney General, they are saying they are exchanging communications. The letter to the principal judge, a letter to the Chief Justice, a letter to the CDF, a letter to the Attorney General, a letter to the DPP. They are just still exchanging communication. They are hiding under red tape, under bureaucracy, to continue violating the rights of Dr. Besigye and other prisoners of conscience. We thought court would bring that to a halt, that would stop that kind of impunity. Unfortunately, it would appear court developed fit of kire and had to delay the delivery of the judgment. So we are going to retreat and see the next course of action, how we shall get a remedy under the circumstances as we await for the court decision in this matter. But we leave these premises with a heavy heart, with disillusionment, and of course devastation. That is it. Kakati tubadde mu kooti naye tugenda nevuunya ku mutima nti tubadde tusuubira nti olwaleero application ene ejja kuwulirwa. Okusooka mujjukira abadde bagifikisinze nga 25 omulamuzi n'atubeerera wa kisa n'akyusa n'agamba nti mujja olwaleero, era ne kituwa essuubi nti bwe tujja olwaleero bw'anaamala okuwuliriza tufune decision ey'amangu. Kitwenyamizza, kituleetedde evvuunya mutima, yadde omulamuzi tumuwa ekitiibwa era tusuubira nti kale agenda kukola omulimu gwe asalewo, naye ayinza okusalawo ng'embeera ndala. Mulabye obulamu Dr. Besigye bwalimu, n'omulamuzi yennyini abulabye, n'okutuusa kati tannafuna mbeera efuna bujjanjabi bumala obutuufu okuva mu badokita yebe yeekyuzingidde, ate n'okuva mu ddwaliro erina obusobozi okukola ku bulamu bwe. Ate nga tubalaze nti okuva nga 31 omwezi ogwa January tewali bano kye baali bakoze, era olwaleero kyeyolese lwatu nti ne bye boogera ebya transferred files bagenda zitwala mu civilian courts tebiriiyo. Kyeraze lwatu kubanga mu affidavit ereeteddwa state attorney bwe bujulizi bwabwe balaga amabaluwa ge beewandiikira nti Attorney General yawandiikira Chief Justice, Chief Justice n'awandiikira Principal Judge, ti Principal Judge n'awandiika ebbaluwa ng'eddamu ya Attorney General, bwe Attorney General bwe yagifuna n'agiwa CDF, n'Attorney General era endala n'agiwa DPP nga bagamba nti kale mukole ku process ey'okutransferinga files. Temuliimu n'akawaayiro n'akamu mu affidavit yaabwe we bagambira nti files zino tugenda zitransferinga era ku lunaku bwe ruti. Ate nga ssemateeka alambika bulungi, tojja kukuumira muntu mu kkomera okuggyako ng'olina ebiragiro bya kooti. Ekyo tuzze tukinnyonnyola enkya n'eggulo. Remand warrant yaggwako, tebalina court order mpya, tebalina kiragiro kya kooti yonna, tebaguddeewo misango mipya. Kakati bakozeseza kye bayita impunity of the highest order. Kyekyo kituleetedde okwennyamira mu mutima. Omulamuzi atugambye tumuwandiikire olunaku olw'enkya tumusabe ddi lw'anaatuwa ensala ye. Weero kyennyamiza naye kale katugende tulabe ekyokukola oba tumuwandiikira, naye kitunyize nti olwaleero tutufunye ensala ku nsonga eyo kubanga kisigadde mu bbanga bwe kiti, era bali baddeyo bakola ebintu byabwe ebyekivandulo nga bwe babadde bakola. Naye tugenda kutuula butuuzi, katuddeyo tukwatagane n'abakulembeze bonna nga bwe mbalaba wano, tulabe ekyokukola ekiri mu mateeka ne mu busobozi bwaffe. Mwebale nnyo, mwebalire ddala.
Yeah. Thank you. All has been spoken by our brother, Councillor Okwago. One thing that I want to put in black and white: this is not prosecution, this is persecution. Dr. Besigye would not be brought to court today if it was not for pressure. You notice this is the same judge that sent Kakwenza to prison instead of sending him to the ICU after grave torture. This is the same judge that said the cash bonanza at Parliament was legal. At the same time, this is the same judge that is sending Dr. Kizza Besigye back to prison instead of sending him to hospital. This is a cadre judge. This is a regime persecuting Dr. Besigye and all other political prisoners in the name of prosecution. My only call is to the people of Uganda here and abroad. The only thing that works with this regime is pressure. I want to thank all those in Kenya, in all of East Africa and all over the world that are putting up pressure. Please put up pressure. From here, we are going to hold prayers at Kavule for Dr. Kizza Besigye and other political prisoners. We are not going to stop. We gave the regime 48 hours to release Dr. Kizza Besigye because we want him alive. They are trying to kill him and all of you see. So I call upon the nation, all people of goodwill, to stand with not only Dr. Kizza Besigye, but all political prisoners, especially those that are in prison illegally, courtesy of now the defunct military court. So stand with Dr. Kizza Besigye and all political prisoners, exert pressure, because pressure is the only thing that works under dictatorial regimes. Thank you very much. Ebisinga kansolo kwaga byogedde ze kyenjagala okwogera mu bulambulukufu nti kuno si kwozesa wabula kutulugunya. Bali mu kutulugunya Dr. Besigye n'abasibe bonna abasibwa mu bumenyi bw'amateeka. Singa teyabadde pressure wano mu Uganda n'okwetolola eggwanga n'okwetolola Africa, Dr. Besigye teyandize mu kooti olwaleero kuba tebamwagala nga mulamu. Ensonga lwaki bamutadde mukomera mu mbeera gy'alimu. Njagala mujjukire nti omulamuzi oyo y'omu Singiza yasindika Kakwenza Lukirabasajja mukomera mu kifo ky'omusindika mu ICU ng'ali bubi nnyo. Ye mulamuzi y'omu eyagamba nti enguzi y'omu Parliament yali mu mateeka. Service award nti yali mu mateeka. That's the same judge that said the service award was legal. Kati ye mulamuzi y'omu yasindise Dr. Besigye mukomera mu kifo ky'omusindika mu ddwaliro. So kuno si kwozesa Dr. Besigye oba abasiba abalala wabula kubatulugunya. Kibagambyeko nti teyandize olwaleero singa teyabadde pressure gye mwataddewo. N'olw'ensonga eyo nze njagala obbasaba mwenna gye muli mutekewo pressure, tubebaza mwenna abeekalakasiza okwetoola East Africa ne wano mu Uganda. Temulekerawo kuba bano bawulira pressure yokka, abatulugunya bawulira pressure. Ne nammwe tubasaba buli omu waali mu ngeri yonna gy'asobola atekewo pressure ku social media, ku street n'awalala wonna wonna kubanga bano bawulira pressure. Mwebale nnyo mwebalire ddala.
I came here expecting to take Dr. Kizza Besigye home today. I'm devastated, but I'm not surprised. Besigye is a captive. He was kidnapped. He's in captivity, as we all are. Museveni has put all of us in captivity. This cadre judge, shame on him. Shame on him to send back to jail a man whose health is deteriorating very fast. But it's all President Museveni and his insane son, who is the army commander or chief of the army, who are holding all of us in captivity. We must liberate ourselves. Enough is enough. Ngambye nti abakulu babyogeddeko byonna. Mbadde nze okulaba omwami wange n'okumutwala eka kubanga talina musango gwonna gwe bamusibiddewo kati. Musibe wa Museveni ne mutabanyi we oyo omusajja omulalu bwe boogera ate ng'akulembera amagye gaffe. Ffenna tuli basibe. Museveni amaze emyaka 40 mu kulembeze naye alinga aguddemu eddalu. Tategeera mateeka, takolera ku mateeka, era ffenna tulina okwerwanako ne twenunula. Mwebale nnyo abazze ab'ebibiina byonna abadde wano fena twegasse wamu okwenunula tewali kirala tulina okwenunula omusajja ne Mutabagi bombi tebali ku mateeka ate ndowooza n'emitwe gyabwe
kati tugenze kavule
omusumba ye n'asaba n'agamba bagawugule gagende wakumukuma 13
naye gavumenti lwakimukugamira ku mitwe
era mbyagalira ddala pulezidenti wange
be twasaba bajje batusabire tebakoze eki tebalabise
tugenda kwekalakasa paka eza paka kulya